Okay, what was your last name again?
Mejorado, M-E-J-O-R-A-D-O.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Boom, this is serious. We're talking up to 6 months in jail, a $2,000 fine, and now we're getting into probable cause. This isn't just legal jargon. This is the point where your freedom starts to slip away.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers responded to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got stuck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odor of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4.
Field sobriety tests are coming, and things aren't looking good. He scored 6 out of 6 on the horizontal gaze and the nystagmus HEN, meaning he failed every clue. Quick quiz. Do you know which of these tests carries the most weight in court?
Stand, the DIC was read, he sentenced it read, and the results were at .148 and a .143. It was identified by his Texas driver's license.
Okay, sir, I'm going to find that there's sufficient probable cause to go forward with the case. You look to see any prior DWIs, if he has.
There's no prior DWI.
Here comes the judge's version of a legal leash.
Here comes the judge's version of a legal leash. Strict bond conditions. No alcohol, no unprescribed meds, no funny business. One slip, and he's back behind bars. There's zero wiggle room.
Mr. Mejorado, I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. We'll have you fill it out. I'll have you sign a reset with Victoria. You'll get with Fleischer for your bond conditions. Then I'll take a look at it shortly. Good morning, ma'am.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9th, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving its own lane side to side. The officer observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant have bloodshot eyes, odor of speech, and odor of an alcoholic beverage on her breath and in person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted.
That's 242. Another DW.
That's 242. Another DWI case greenlit. Notice how fast this is moving. The judge is slicing through cases like a seasoned chef. But here's the question. Is this efficient justice or just legal speed?
Walk and turn, and a 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The results were at .137 and a .132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. You also look prior DWI's license, please.
Yes, Your Honor.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Judge, on the testing, what is that? Pass on that message.
Just random testing. No alcohol, no dope.
Okay.
illegal drugs.
I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gotta, I mean, don't come in 2 weeks though.
No.
Right. But yes, of course.
License eligible, no prior DWI.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, then you're free to go, man.
All right, thank you very much.
Have a good day.
Yeah.
Right here in front of the judge.
Good morning, Mr. Robinson.
Good morning, sir.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 7th, 2025, in Harris County.
Just like that, the DWI courtroom shifts gears into a potential threat case, an alleged gun threat, a slow reach into the bag. This is textbook escalation. But here's the real question. Does it rise to the level of a terroristic threat?
The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 p.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is it?
I don't know. But when the complainant, we did not charge a trespass in this case. So when the complainant said you're not allowed to be there, we leave back at 11, and that's when the responded to
Can
my
you say it again? What did he say again?
The complainant repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was therefore trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with his left field first.
He said, I'm going to get my gun and shoot you?
I don't have it both ways. Say the defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bag.
Ask a question.
Who wrote the report? The actual officer who got threatened or someone else?
Critical moment. The judge cuts him off.
Critical moment. The judge cuts him off mid-explanation. Why? Because anything said can and will be used against him. That's not just Miranda line. It's strategy. Never argue your defense at arraignment.
The officer did not write the report. I mean, the officer wrote the report, not the security guard. The security guard was the one who was threatening the
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do. Right.
If I might say real quick, I know you're busy. They have a city ordinance. That's why you can't lay at 11. But I was recently jumped. I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what.
I understand.
Okay.
Because the defendant works this location,